Your case has been refused, you're disappointed naturally, and your plans for Hong Kong have been dealt a severe body blow. So what can you do? The answer is to apply to have the decision to refuse your application reconsidered by the Hong Kong ID. But be warned, it is an uphill struggle, and you only get one good shot at it, so you better make it count. The Immigration Department will entertain an application for a reconsideration of a decision to refuse an application if there is significant additional new information adding weight to the original application, or relevant and important new facts which have come to light since the refusal. And of course, you have to be able to submit comprehensive verifying documentation to support what it is that you're saying.
So it's very useful to begin with asking the questions, why do applications get denied? Well, there are some very key fundamental reasons that tend to present themselves wherever there has been a case refusal, and we'll examine these now. The first is that a case could be fatally flawed from the outset. What this means is that the minimum approval criteria, the requirement, for example, of a legal marriage for a dependent visa that isn't present, or there could be security considerations, or there could be issues where the case is simply just not approvable right from the very outset because of a case of previous denials or a poor history with the Hong Kong Immigration Department. All of these taken together, could be a major contributing factor to why the case was never going to get approved, even at the point of submitting it. Another reason why cases get denied is that, frankly, they've been prepared in a very poor manner. The person who's been responsible for the visa hasn't readily understood what the Immigration Department are looking for. They haven't appreciated that there is an approvability test to each and every visa type, and that what is said and the rationale for the status in the first place needs to be satisfied through the paperwork and everything else that goes to make up an approvable situation. And very often, especially in HR departments of companies which tend not to have a lot of experience in doing Hong Kong visa cases, they look at the document list. They think that just the mere submission of the documentation will be sufficient for the granting of the visa, treated on purely an administrative and not an argumentative basis. And consequently there's been no effort to try to justify why that particular individual should be granted the employment visa in those circumstances, and consequently the approvability analysis has fallen over, and so the Immigration Department has said no. Another reason for cases being denied is that the requisite Immigration Department information requests have not been satisfied. The Immigration Department approve cases or consider cases on the basis of the documentation that is presented before them, and for one reason or another some applicants are unable or unwilling to submit paperwork that is critical to the entire outcome, and consequently this works towards having the application refused rather than approved. In the similar light, if the Immigration Department asks for something, if you want them to grant the visa, you have to give it to them. We've seen cases down the years where applicants or their employers simply say, I'm not submitting my financial information because it's confidential. That may well very be the case, but the Immigration Department are a government organisation. They've got significant obligations of confidentiality, and in the final analysis, again, if you want the Immigration Department to be empowered to allow an approval to be forthcoming, you've got to empower them to have the approval to be forthcoming. Another reason why cases get denied, frankly, is that the applicant has been breaching his conditions of stay whilst his application has been ongoing. It's quite unrealistic to expect the Immigration Department to subsequently approve an application for an employment visa if they've raided that person's potential workplace and have found him engaging in activities which are not commensurate with his visitor visa status, or in fact if he's applied to work for a new employer but he's doing something else that isn't commensurate with his current immigration status. So if you're caught breaching your conditions of stay, there's a very discrete possibility that you'll end up having your in-principle visa application not approved. So now that we've covered the reasons why cases get denied, what are the challenges associated with requesting a case reconsideration? Well, the Immigration Department processes and procedures are set up to receive case reconsiderations, and they will accept a reconsideration. They will not just reject it at face value. They will receive it and they will give due consideration to the reconsideration accordingly. However, the reality is that a reconsideration, just like all appeals, is an uphill struggle. You are now swimming against the tide. The Immigration Department have had one really good look at it, and you need to be able to satisfy the reconsideration approvability criteria for the expectation, any kind of hope that you will get approved subsequently. So, first thing to do is to ask the Immigration Department for a copy of the file under the data privacy rules. This will mean a few days later you will receive a copy of the paper file that they have on you. It will be heavily redacted, but you will get some kind of sense for what has gone on during the primary consideration of your application that could guide you as to what might be going wrong with your substantive argument. The next thing to do is to try to speak to the examining officer in person and respectfully question him to try and get a feeling for the kind of concerns that the Immigration Department have with the case. Depending on the officer and depending on how marginal the approval has been, they may be very forthcoming and tell you what problems they have with the application. But very often they keep their cards very close to their chest and are not prepared to really let you understand what the substantive reasons for the refusal has been. So if you're in Hong Kong as a visitor and you are in the throes of submitting an application for reconsideration, then the Immigration Department do, as a matter of course, allow you to remain in Hong Kong as a visitor until such a time as your case reconsideration has been completed. Turning now to the prospect of arguing the reconsideration, as we saw in the short introduction, the grounds for reconsideration is that you have to have new and previously unsubmitted information that effectively wasn't available at the time that the original determination of the case was put to you. What this translates in real terms is that you have to have something substantive that is going on subsequent to the original application having been submitted. It's not sufficient to make an emotional appeal, throwing yourself at the feet of the Immigration Department saying that it's turned out to be a financial disaster for you and your family if as a result of you not being granted the employment visa approval. You should not be just rehashing the original representations and promoting the same old argument. Just reshuffling the papers isn't going to do anything. And again, going to your local Chamber of Commerce or to your local consulate and asking them to make representations in writing as to what a great contribution you will make to Hong Kong is not going to add anything to the overall outcome in terms of the original refusal. So it's not recommended that you take those tacks. No, what you need to do is to put a rock-solid argument forward. So, there's got to be significant new information which adds weight to the original application and or relevant and important new facts which have come to light since the approval. And that should form the basis of your really one shot at trying to get the Immigration Department to change their mind. Moreover, whatever it is that you're articulating in your argument has to be supported by comprehensive documentation, and these must support, in no uncertain terms, the new information or the facts. And you really only have one good chance at it, so make it count. When you're making an application for a reconsideration, the Immigration Department will be letting you know very quickly as to whether your case has merit or not. Experience has told us that where a case does not have any real merit, the Immigration Department will get back to you quickly. Sort of 10 days to 2 weeks is the sort of time frame. So you'll know very quickly whether or not you're at least in with a fighting chance of success on your reconsider application. If it does have merit, it'll take anywhere between 6 and 16 weeks. But do bear in mind the mere fact that you've gotten into week 3 of the reconsideration time frame. Don't take it as given that you will be approved. As I've mentioned, the reality is that all reconsideration applications are an uphill struggle, and whilst it might take 3 to 4 months for the process to play itself out, there's every possibility at the end that your case will be denied in as much as it would be approved.
The next step is for you to review the visa information document. This details each of the essential elements of a successfully argued Hong Kong visa case and contains in-context links to all of the resources needed to prepare your application. These include application templates, the online application forms, screencasts on how to complete the forms, a checklist of all the documents you need to prepare as part of the submission bundle, a crib sheet on how to submit your application, and audio discussions of some of the finer points of official policy and procedures and specific case examples from the past which will serve to help you by way of illustration. Let's go to the visa information document now.